Greetings. In this segment, we are going to discuss the concept of judgment writing. And not just judgment writing, we are going to deal with a variety of issues and different areas related to this topic of judgment writing. We'll be discussing the framing of issues. We'll be discussing the framing of charges. We'll be discussing marshalling of evidence, appraisal of facts, and ultimately we'll go towards the judgment writing part, wherein we'll be dealing with civil judgment writing as well as criminal judgment writing. See, first let us understand what is the basic need here. Judgment writing, when we talk about states like, let's say, Uttar Pradesh, or states like Chhattisgarh, where you have the entire mains examination is based on judgment writing. States like Uttarakhand, Rajasthan, Jharkhand, Madhya Pradesh, very important. Sometimes you will find this in Haryana and Delhi also. The examiner asks you to frame a judgment, either a civil judgment or a criminal judgment. The examiner sometimes even asks you to frame issues, Uttar Pradesh specifically, to frame issues, or even to frame charges. Now, in this course, we are going to deal with some practical situations with you. First, we'll go towards the basic concept. For example, when we'll go towards charge framing, we'll first understand as to what is a charge, what are the different provisions in BNSS related to charge, how exactly is a charge framed. When you see in the schedule of CRPC, when you see form number 32, you will see the model form of charges. Now, this model form of charges only gives you an idea, a very important one that too, gives you an idea as to what is the format for the framing of a charge. If there is an abetment, the offense is relating to abetment, then will it be a separate charge of abetment, or will it be the charge of the offense only and abetment will not be mentioned? Let us say it is a criminal conspiracy, then what will happen? Achha, how do we reach the point of charge framing? You see, when there is a criminal process, it generally starts with the registration of an FIR. Generally, it starts with the registration of an FIR. Then down the line, you can have provisions of Chapter 5 which are related to arrest. I am dealing with CRPC here. Chapter 5 which is related to arrest. There might be 160 and 161, that means calling of the witnesses and examining them by the police officer. There will be a situation of section 164 also, because if there is arrest, there might be confession or statement of the accused being recorded by the magistrate. Of course, time and again there will be productions under section 167, where the accused has been arrested. Within 24 hours, you will have to produce the accused person before the magistrate, and then subsequently for interchangeable custody between police and judicial, you will have to produce before the magistrate under section 167, and then subsequently when police custody gets over, then 15 days interval, you will have to produce the accused under section 167. After this production under section 167, a very important stage comes, and that stage is the filing of the charge sheet. You file the charge sheet here. Now, when we say filing of the charge sheet, this is an incorrect term. Sir, kya bole fir ise? We call it the police report. Now, when you are writing a judgment, if you write charge sheet, it necessarily means that the police has found sufficient evidence subsequently after the investigation, the police has found sufficient evidence against the particular accused. That is what is the meaning of charge sheet. When I say closure report or deferred charge sheet or negative challan, that means it will be a closure report. That means the police subsequent to the investigation has not found sufficient evidence against this particular accused. We basically here refer to two situations. Number one is the situation of 169, which is deficient evidence. That, sir, I have concluded my investigation and I have not found any sufficient evidence against this particular accused. That is the case of deficient evidence. Or there is the case of sufficient evidence under section 170 of CRPC, wherein you file the police report or charge sheet. What I am trying to tell you is what all is relevant here when it comes to the framing of charges. This police report contains the allegations which the police has made against that particular accused. So the police is saying, sir, according to the evidence collected, according to so and so witness's testimony, according to so and so call detail report, according to so and so CCTV surveillance footage, we have come to the conclusion that this particular accused or this set of accused persons have committed this or these list of offences. Now, this is just an allegation by the police officer. Is the court bound by the charge sheet? Absolutely no, never. The court is not bound by the charge sheet. What should the court do? The court will conduct hearing, which is also called arguments on charges. And then subsequent to this hearing, there will be a stage of final charge framing, wherein this charge meaning the formal accusation. This formal accusation will be leveled by the court against the accused, that now police and everything over, the court is formally accusing you of doing this offense. आपने ये offense करा है, ये हमारी accusation है आपके ऊपर, और इसी charge के basis पे the trial will start. Trial in fact starts in warrant cases with the framing of charge. So the charge will be framed and the trial will start. Trial में the prosecution will prove the charge and the defense will try to disprove the charge. Now, how are these charges framed? That totally depends upon the discretion of the court. Now, with the allegations which have been leveled by the police against the accused, will file the charge. अब sir, ये charge framing पता कैसे चलेगी? For the purpose of charge framing, there are a few things that you need to know. Number one, you should know the relevant law, not just related to charge framing, but you should know the substantive law as well. Because what will happen in the examination, a set of facts will be given to you. Sir, ये facts है, इस बंदे ने ये करा था, ये इस जगह पर गया था, यहाँ से गाड़ी की नंबर प्लेट चुराई, उसके बाद जाके वो एक घर में घुसा, घर में घुस के उसने एक व्यक्ति को थप्पड़ मारा, उसके बाद रस्सी से बांध के एक जगह बैठा दिया, उसके बाद उस व्यक्ति ने वहां से ये चीजें चुराई, and ultimately we have reached a situation where this person has committed this act. Offense नहीं बताएंगे, ये सारे acts करें. अब उन एक्ट्स के बेसिस पे आपको ऑफेंस खुद डिटरमाइन करना पड़ेगा, दैट दिस इज द ऑफेंस अकॉर्डिंग टू दिस एक्ट. नाउ हाउ विल यू कम टू नो व्हाट इज द ऑफेंस? यू विल ओनली कम टू नो व्हाट इज द ऑफेंस वंस यू नो द सब्सटैंटिव पोर्शन ऑफ द लॉ. अगर आपको सब्सटैंटिव लॉ नहीं पता तो आपको ऑफेंस पता ही नहीं चलेगा कि कौन सा कमिट हुआ है. व्हाट एल्स डू यू नीड टू नो? अगेन, you need to know the form of charge. See, form is not important, substance is important, but form has to be known. For example, there might be a situation, because when we'll do charge framing, we'll understand whenever charges are framed, you tell me as a normal human being, because judges, though they are well trained, they're also human beings. You tell me with the particular set of facts, are you always 100% sure that this is the offense that this person has committed? The answer is no. There comes the situation of alternate charges or doubtful charges. वो भी हम पढ़ेंगे. Alternative में भी charges frame हो सकते हैं. That you frame one charge or the other charge or the other charge. It is very much possible. So charges can be framed in the alternative also. There might be doubtful charges also. That means I think this or this or this or this. There are 4 possible offenses. Let us conduct a trial and then understand what offense has been committed. That is what the trial is for, to understand which offense has been committed by the accused. So there can be doubtful charges also. You need to know the form. How will a doubtful charge or an alternate charge be framed? When you read form number 32 of the schedule in CRPC or BNSS for that matter, you will come to know. You will automatically come to know that, okay, this is the format in which the charge has to be framed. But how will you frame the charge? You need to know the substantive portion of the law. You need to know the procedural portion of the law. That is the form as well. Because ultimately, it is this procedural portion which is going to tell you in which situation what charge is to be framed. Now, let us say if I tell you that a charge of murder is to be framed under IPC, any act committed post 1st July, let us say a charge for murder has to be framed under IPC. Now, murder has been defined in section 300. Will you frame a charge under section 300? Absolutely no. Charge is always framed of the punishing section 302. That will be the charge. Charge is never framed of the definition clause or the definition section. It is always framed with the punishing provision. For example, when you talk about theft, section 378 of IPC, the charge will not be framed under 378. It will be under 379, which is the punishment for theft. Now, when we talk about charge framing, it will be unjust not to talk about the framing of issues. Now, sir, what do we understand by issues? Issues are, you can say, the questions or the point of contention in a civil process. Charges are in criminal law. The point of contention are in a civil process. For example, let us say A is filing a suit against B and he is saying that there is a breach of contract. And he is asking for, let us say, 10 lakh rupees as damages. Now, when he asks for 10 lakh rupees as damages, B says that I have not breached the contract. मैंने contract breach नहीं करा है. The first question in front of us is, has B breached the contract? And who will prove this? It is very much clear. The burden of proof will be on the person who wants the judgment from the court. Who wants the judgment? A. So A will prove that yes, B has breached the contract. Tabhi A ko relief milega, because A is saying that B has breached the contract. So if A is alleging that B has breached the contract, agar tum allege kar rahe ho A, to tum hi proof karoge. So the onus of proof will be on the plaintiff OPP. That is onus of proof on the plaintiff. This is one issue. The second issue will be, now he is claiming 10 lakh rupees as damages. So is B liable to pay 10 lakh damages? हो सकता है पहले ही कॉन्ट्रैक्ट में लिक्विडेट कर दिए हो डैमेजेस, फिक्स कर दियो 5 लाख रुपए और A 10 मांग रहा है. So here also the onus of proof will be on the plaintiff. You understand, these are issues. There can be, if you see order 14, you will see when we talk about issues in order 14 of CPC, you will see issues are basically of two types: issues of fact, issues of law. We will focus on issues of fact. हमें fact से मतलब है. यहां पर भी क्या करेगा एग्जामिनर? द एग्जामिनर विल बेसिकली गिव यू अ सेट ऑफ फैक्ट्स एंड देन you will be required to frame issues. Issues meaning, again, charge or issues, दोनों they are the pivot of the particular case. Around this charge in criminal cases or around this issue in civil cases, the entire trial revolves. जितनी भी judicial process है वो सारी की सारी इस particular charge या issue के आसपास ही revolve करती रहेगी. Now, when we go to issues, and that too particularly issues of fact, because we are not bothered about issues of law here. That is a part when we do CPC in detail, then we'll do issues of law. But we are only concerned about the issues of fact here. We deal with such issues of fact, and then we try to understand how the trial will be given a direction. Because ultimately, it is possible with you also to understand that if you are not given a question, do you know what to write? The answer is no, you can't know what to write. Sir, if you ask a question, then only we'll be able to answer. But when you see the question paper says something about a particular topic. It asks you a question. You get a direction what to write. अगर मैं आपको एक CPC बोलूं कि यार ये CPC का question paper है, and if I give you blank sheet, there are no questions on it, what will you write? Nothing. Or do I expect you to write everything that you know about CPC under the sun? Of course not. Questions give you directions. Questions will set the direction as to what has to be written and how much has to be written. Issues will give you a direction. What has to be proved, till what extent it has to be proved. This issue framing is very important for giving direction to a trial. किस डायरेक्शन में ट्रायल जाएगा? अब मैं अगर इस पर्टिकुलर बी के एडमिशन को चेंज कर दूं, बी ने यहां पे डिनाई कर दिया कि यहां पे मैंने कोई भी ब्रीच ऑफ कॉन्ट्रैक्ट नहीं करा. लेट अस से बी सेज आई हैव नॉट एंटर्ड इनटू एनी कॉन्ट्रैक्ट विद ए. तो अब आप जो इशू बना रहे थे, इज देयर अ ब्रीच ऑफ कॉन्ट्रैक्ट, उससे पहले एक इशू बनेगा, इज देयर अ वैलिड, नॉट जस्ट अ कॉन्ट्रैक्ट, अ वैलिड कॉन्ट्रैक्ट बिटवीन ए एंड बी. अगेन हु विल प्रूव दिस? द प्लेंटिफ विल प्रूव दिस. व्हाई? बिकॉज द onus of proof will be on the plaintiff, because the plaintiff wants a judgment from the court. B is saying I have not entered into any contract. Mr. A, is there any contract? पहले contract तो prove करो. A कहेगा sir ये रहा contract. First issue will be decided in the affirmative. Is there a valid contract between A and B? Yes, it is decided in the affirmative if the contract is proved. If no, पूरा सूट ही खत्म हो गया. Contract का breach मांग रहे हो, damages मांग रहे हो, पूरा सूट ही dismiss हो जाएगा. क्यों? क्योंकि ना contract है ना breach हो सकता है. So, depending upon these facts, this particular issue keeps on changing. If I change the facts, issues will also change. So, the examiner will give you a set of facts, a constant set of facts. You need to examine what the facts are and then frame issues that from these facts, these issues will be determined. For that, we'll need to understand a little bit about CPC, primarily Order 14. Now, something which is more advanced than the framing of issues or the framing of facts is judgment writing. Now, judgment writing is primarily of two types, criminal and civil. Now, as the name suggests, civil judgment writing is basically related to a set of facts where some civil legal rights are involved. For example, let us say partition of a joint Hindu family, which is one of the favorite areas for civil judgment writing, or dissolution of a partnership firm, or the exercise of right of lien in the Sale of Goods Act, or the exercise of rectification under Specific Relief Act. or the exercise of, let us say, the relief of cancellation of an instrument under the specific relief act. अब आपको ये भी समझना पड़ेगा कि इंस्ट्रूमेंट और कॉन्ट्रैक्ट में क्या फर्क है, because there is a difference between instrument and contract also, they're not the same thing. Rescission हम कॉन्ट्रैक्ट का कर रहे हैं स्पेसिफिक रिलीफ एक्ट में, if you see section 27, बट कैंसलेशन हम इंस्ट्रूमेंट का कर रहे हैं. So is there a difference between instrument and contract? That also has to be examined, but these are all very small points. The major thing that we need to understand is the appraisal of facts. For this, we need to have with ourselves a background of the Indian Evidence Act. Till the time there is appraisal of facts, we will not be able to understand the concept of judgment writing. Appraisal of facts का मतलब क्या है? Let me give you an example. Let us say I say that W was married to H and she married 3 years ago. From the time of the marriage, H has been very kind and compassionate towards W. And this fact is known to all the relatives and friends of W and H both. It is visible from the communications between H and W as husband and wife. It is visible from the opinion of the relevant family members also who have seen them as husband and wife. Later on, after approximately 3 years, W is found dead inside her washroom in a very suspicious manner. And the family members of W have filed a complaint that they suspect that H's brother, that means W's brother-in-law, has committed the murder of W because H's brother-in-law was sexually advancing towards W and she was repeatedly denying his request. Now, this is the set of facts which has been given to you. अब इसमें एविडेंस दिया जाएगा. एविडेंस आपको क्वेश्चन में मिलेगा. क्या एविडेंस होगा? एविडेंस आपको बताएंगे कि भाई जो एच के ब्रदर इन लॉ है, लेट अस से मिस्टर बी, एच के ब्रदर इन लॉ नहीं, डब्ल्यू के ब्रदर इन लॉ जो है, एच के ब्रदर जो है, लेट अस से मिस्टर बी, ही हैड सेंट सम ludicrous, unappropriate texts to W. The house help has given his testimony, a statement to the police that साहब ये जो बी थे ये बड़े खतरनाक हैं और ये बहुत गुस्से वाले थे और एक बारी मैंने इन्हें देखा था कि ये डब्ल्यू को बहुत ज्यादा डांट रहे थे और उनको कह रहे थे कि तुम मेरी बात क्यों नहीं मानती हो और जब मैं तुम्हें कह रहा हूं कि एच चला जाए घर से तो मेरे पास आना, तुम क्यों नहीं आई. Now this is another set of evidence. Now there might be a situation where H denies all these allegations. H says that no, B is impotent. How can he sexually advance towards W? That is why B is unmarried. My brother is unmarried because he is impotent. Now you will be given such set of facts. You will be required to pronounce a judgment. And there will be some additional facts also. You will be required to pronounce an entire judgment. But for that you need to appraise these facts as to which fact is relevant under the Indian Evidence Act, which fact is irrelevant according to the Indian Evidence Act, because under the Indian Evidence Act, section 165 and I think BSA it is 168, it very clearly says that judgment has to be based on relevant facts only, and evidence will be allowed only for relevant facts and no other facts. That is section 5 of Indian Evidence Act. You will only be allowed to give evidence related to relevant facts and nothing else. So you will have to focus only on relevant facts. So what facts are relevant? What facts are irrelevant? You need to distinguish between the two. And this will go hand in both criminal cases also and civil judgment writing also, because both places Evidence Act plays a role. Now if you want to see what is the quantum of damages, you will have to mention section 12 of the Indian Evidence Act. If you want to understand whether this custom is relevant or not, you will have to go to section 13 of the Indian Evidence Act. If you want to see whether in the ordinary course of nature this has been happening with all the employees in that organization relating to their respective employment contracts, you will have to refer section 16 of the Indian Evidence Act. Civil cases also, criminal cases also, Evidence Act is going to play a very, very important role in your entire process of judgment writing, be it civil, be it criminal. अब वो सिविल केसेस में आप जजमेंट राइटिंग कर रहे हो, मतलब आपको फैक्ट्स दिए वो किसी सिविल लीगल राइट के हैं, एज आई टोल्ड यू, डिसोल्यूशन ऑफ पार्टनरशिप फर्म, और लेट अस से देयर माइट बी पार्टनरशिप firm is being dissolved, or partnership firm is being sued by somebody, or there might be partition in a joint Hindu family, or there might be a breach of contract, something as simple as a breach of contract, maintenance under the Hindu Marriage Act. So you understand that there might be variety of issues which will come in front of you. But out of those issues, you need to take out the relevant ones. And only those relevant issues or fact and issue will be the center point of your entire judgment. We'll be doing a lot of exercises in this particular course. And in the process of learning this, we'll definitely touch upon a lot of laws, not in detail, because that is not the purpose, and we don't even have that much luxury of time to deal in this particular course, the length of the subject. We'll be touching upon a lot of issues and lot of laws. The course starts from the 19th of July onwards, and we'll be doing sufficient practice as far as the judgment writing is concerned, charge framing is concerned, and the framing of issues is concerned. So I suggest all of you, you please buckle up. If possible, you read the Evidence Act section 5 to 55 from any standard book if you want to, or the Bare Act would be sufficient, because I'll be dealing with some particular portions here and there. If you want to read the chapter of charge in CRPC, that will also be very relevant for you in the examination as well as in the process of judgment writing. Same goes for order 20 of CPC and order 14 of CPC, where judgment is also discussed and issues are also discussed. So I'll meet you in the next lecture, where I will find you with some starting points, initial discussion regarding judgment writing, both civil, criminal, charge framing, framing of issues, and marshalling of evidence. Fine. All the best. Thank you so much.